I think that was a beautiful story, Dr. Williams, about the potential of abolition with, say, $500,000 per person, right? One could imagine very well being surrounded by people taking care of your welfare. Of course, not in an institutional context, but having housing and therapy and a lot of other things. There's a swelling movement for abolition of prisons today. It's part of a broader abolitionist movement challenging not only prison and jails, but also the police, juvenile detention, and other coercive arms of the state. New abolitionists, new in relation to the earlier movement for abolition of chattel slavery, new abolitionists such as Angela Davis, Dorothy Roberts, Mariam Kaba, Andrea Ritchie, Ruth Wilson Gilmore, Derricka Purnell, and others have reached wide audiences and, in the words of Amna Akbar, catapulted abolition in the mainstream and unsettled the intellectual foundations of reform discourse. Many people, including many progressive thinkers, consider the emerging debate over abolition to be a nuisance, or worse, something that's driving a wedge within progressive circles. You lose a big audience the minute you say it, President Obama said on a talk show in December 2020, which makes it a lot less likely that you're actually going to get the changes you want done. Many progressives agree with this sentiment, fearing that the new abolitionism will backfire and push the country in a more conservative direction. In the short time I have with you, I'll argue that far from a nuisance or distraction, the new abolition is one of the most productive developments in contemporary legal and political thought. As a political matter, it's been a powerful force for social change and brought about the largest and most diverse social protests in American history, as Elizabeth Hinton demonstrates in her powerful book, America on Fire. It's also given birth, in Elizabeth's words, to a global movement for racial and economic equality. But I'm not going to speak to you today as a political strategist. That's not my forte, maybe not yours either, which is why we're all in this room. Instead, I will speak as a political and legal thinker. And at that level, the new abolitionism is most productive and important because it forces us to address the central challenge to our most dearly held political beliefs. And it poses the question whether contemporary punishment practices in this country are really a response to crime or instead constitute chiefly a mode of governing that imposes ethnic, gender, racial, and other unjust social hierarchies. The question goes to the heart of liberal political theory and the central tenet of liberal democratic societies, by contrast to autocracies, that we are governed by the rule of law. It translates in the penal context to the idea that there is and must be a legitimate relationship between crime and punishment. And the legitimacy of that relationship founds our liberal state, as all of the philosophical, literary, and juridical discourse on crime and punishment illustrates, from Hobbes and Locke through Cesare Beccaria, even Dostoevsky, to John Stuart Mill, to John Rawls. The new abolitionists take on that view and argue instead that the enforcement of criminal law serves more importantly to impose forms of hierarchy on society and keep African Americans and other persons of color in a condition of second-class citizenship. Now, critical social theorists have posed this challenge for over a century, but really to no avail. And it's only now, as a result of this new wave of abolitionist writing, that the challenge is becoming part of a national debate. And for that, I think we should welcome the abolitionist movement. Now, W.E.B. Du Bois was at the fountainhead of that critical tradition. In his path-breaking book, Black Reconstruction in America, published in 1935, Du Bois demonstrated how the enforcement of criminal law was used as one of the main devices to functionally re-enslave freed Black women and men after emancipation. Through the implementation of Black codes in the former Confederate states, which imposed severe punishments and labor restrictions on African American men and women, new punitive practices of convict leasing and plantation prisons emerged that gave birth to new forms of slavery. As he wrote, the whole criminal system, Du Bois said, came to be used as a method of keeping African Americans at work and intimidating them. The enforcement of the penal law essentially replaced property law as the principal stratagem to perpetuate white supremacy. Now, writing at about the same time, a group of critical thinkers, members of the Frankfurt School, then in exile at Columbia, also set out to challenge the link between crime and punishment. In their pioneering book, Punishment and Social Structure, published in 1939, Georg Rusch and Otto Kirchheimer reviewed the history of Western punishment practices since the 17th century and demonstrated their inextricable interconnection with the labor needs of those in power. Rusch and Kirchheimer unearthed evidence, for instance, showing how punishments such as transportation and the galleys served primarily to uphold the Ancien Régime. The evidence was hidden in plain sight, in letters and official correspondence between the monarchy and the judges and prosecutors. Here's one. This is a king's administrator writing to the public prosecutor of Paris in 1676. Since His Majesty urgently needs more men to strengthen his rowing crews, he wishes you to take the necessary steps in his name in order to have the criminals judged quickly. In response to such a request, the public prosecutor at Bordeaux wrote back, "You'll be gratified to learn that this court has 20 prisoners who will be chained together this morning and sent off." Rusch and Kirchheimer went on to meticulously trace how imprisonment and labor and prison labor were used since the Industrial Revolution to help negotiate the fluctuating supply and demand for workers. Many other critical thinkers pursued this line of inquiry. Angela Davis underscored the need to do the ideological work of pulling apart the conceptual link between crime and punishment. Frantz Fanon argued that colonial policing was a political weapon to control populations living under colonial rule. In his book on the birth of the prison, Discipline and Punish, Michel Foucault built on this theoretical foundation to expose the work that the disciplinary practices of the prison achieve, right? And he would say, we must first rid ourselves of the illusion that punishment is above all, if not exclusively, a means of reducing crime. In this, of course, Foucault was explicitly building on Rusch and Kirchheimer. He emphasized that their work, in his words, leur grand livre, provided a number of essential reference points. First and foremost, the need to break the link between crime and punishment. Since the turn of the 21st century, new abolitionists have built on these foundations to highlight the political nature of law enforcement and to deconstruct the supposed relationship between crime and punishment. Dorothy Roberts, in her articles on Abolition, Miriam Kaba, all have really aimed at that particular connection. And I think we should heed their call. Roger Cohen, in his keynote yesterday, emphasized the importance of experience, of firsthand experience, of seeing things in tangible reality, not just on the screen, not just on Google, not just in photos, but actually being there. You may recall he said, you have to see to feel. Well, for the past over 32 years, I've been representing people on death row in Alabama and doing prison litigation in addition now to teaching and writing. I've also represented men and women elsewhere, a man at Guantanamo with my co-counsel Tom Durkin. I've been in and out of jails and prisons, including Rikers, where I've been teaching, always fortunate to be able to leave as an attorney or professor, always with a pit in my stomach leaving behind a man or woman. I can only speak of my own experience. Others have had more. I cannot talk for others. But my 33 years of going inside and out of prisons and jails and my work on these Alabama death penalty cases have convinced me to a moral certainty that our prisons and punishment function not so much to prevent crime as they do to impose a social order. When I walk into the prison, whether it's Holman or Donaldson or Limestone Prison in Alabama, or whether it's Cook County Jail in Chicago, or Rikers Island, or the Supermax in Florence, Arizona, when I see and experience it, when I represent men on Alabama's death row, I can see that these institutions are not so much about criminal responsibility, but about controlling a segment of the American population, the poor, persons of color, persons with mental disabilities. When I started working, one of my first cases with Brian Stevenson involved a young man named Willie Rousseau. He was a poor, disabled man, tried in Pike County, Alabama. He told his judge that he didn't want to be represented by his two appointed attorneys because they were racially prejudiced against him. The judge dismissed his complaint and told him they could have those attorneys or represent himself. Willie Rousseau chose to go to trial alone. Clerk of the court struck his jury for him. He offered no opening statement. He didn't do cross-examination of any of the 20 state witnesses. He did not present a defense or call a witness of his own. Mr. Rousseau sat unaided throughout his capital trial, uninvolved in the proceedings. This gives you a sense of how the transcript read. Do I assume, sir, by your silence you're telling me I do not know? Nothing. Is that true? Nothing. Do you wish to answer? Nothing. I assume not. Nothing. Are you a male human being? No answer. At the end of this legal process, Willie Rousseau was sentenced to death by electrocution. One of the next cases I had was a young black man, Pernell Ford, severely mentally ill. He'd been institutionalized and treated with psychotic drugs since childhood. He didn't sit quiet at his trial. At his sentencing, Pernell Ford dressed himself in a white bedsheet with a belt and a shoulder strap made of a white towel, and in a rambling, disjointed sermon, clutching tightly to his Bible, pounding on the prosecutor's table, standing at times on the prosecutor's table, in a loud voice, arms upstretched, pleaded with the judge to bring the two dead bodies in the courtroom because his God would raise them from the dead. The colloquy, well, his monologue, his soliloquy of madness went on for 25 transcript pages and was never stopped by the judge. 25. He didn't appoint an attorney for him or anything. 25 pages. That's longer than some of the evidence presented in mitigation of my defendants at trial by other attorneys. Pernell Ford never received a new sentencing. He was executed on June 2nd, 2000. Another case, Doyle Ham. In this case, this is just more of the colloquy. In this case, the prosecutor, the Attorney General of the state of Alabama, wrote the judge's opinion. 89 pages. 89 pages. It was filed on a Friday night, December 3rd, 1999. It was signed by the judge on Monday morning, December 6th. The judge did not even take off the proposed on the memorandum opinion. For the rest of this case, every federal court relied on this decision under the AEDPA, you have to, last state opinion, that was written by the prosecutor. Supreme Court didn't care. No one cared. Doyle Ham was ultimately set for execution. Ultimately, he survived. He was 61 years old. He had cancer, and he was riddled with cancer, and spent 2.5 hours on the gurney, being pricked and prod in his groin, and walked out of the death row. Now, I'd like to think those are old cases, but in an active death penalty case I have right now, at my last hearing in federal court in the Middle District, this was about 2 years ago, the prosecutor was standing next to me and had in his possession a letter written by a co-defendant who took responsibility for the murder, and that letter had never been turned over to defense counsel, and he would not turn it over to me. He had that letter in his possession, wouldn't let me see it, get my hands on it. even though that's the most basic rudimentary due process right, to be able to receive material exculpatory evidence. The case has been going on for 14 years. I've been on it for 2. I still don't have the letter. What's going on there is not about justice, it's not about crime, and it's not about responsibility and accountability. It's about maintaining a social order. The new abolitionists are training our attention on something that we tend to only see in the distant history. We look back in history and things become clear. When we dust off the archives of the Spanish Inquisition centuries later, it becomes so evident that the popes and cardinals, the grand inquisitors, were imposing an ecclesiastical order on society. They weren't just punishing people for crimes, they were enforcing a social structure. When we discover those hidden letters of the kings, their motives appear so transparent today. We see through all that so easily. When we read the harrowing history of the fugitive slave laws in this country, it all becomes so obvious, branding on the face for a first offense, castration or cutting an ear off for a second, severing the Achilles tendon for a third. Those mutilations were not just punishment for black men and women who escaped their capture. They were a way of viciously imposing white supremacy and a new form of capitalism, racial capitalism. We see things better with the advantage of time, but we don't always have that luxury. In the present of the fog of the present, we fail to see things. So let me conclude. This is, I believe, what the new abolitionists open up for us today. And for that reason, they represent some of the most productive and important challenges to our society. I was going to speak a little bit about how we choose to spend $500,000 per person at Rikers, but I think we've already covered that. But I think that's a reflection of how it is that we're making our choices and how it is that it's really a social and a racial order that we're maintaining with our prisons. And so I would urge everyone to open your ears and your eyes and to open your minds to the new abolitionists. Thank you.